So what has he done on probation other than pick up new cases? So then here's my question for you. Why should I give you less than what you bargained for when the only thing you've done is report 3 times and you picked up a new case? Could I have parties announced for the record?
Attorney Bill Simmons for defense.
And are you Paul Anthony Ramirez?
Yes, ma'am.
Okay, on this case, could I have the original motion to revoke? I only have the first amended. Mr. Ramirez, did you review the motion to revoke community supervision and first amended motion to revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Paul Anthony Ramirez who was placed on community supervision in 2024 CR 009393 for the offense of possession of a controlled substance penalty group 1, 4,200 grams on October 31st, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant, Paul Anthony Ramirez, did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Your Honor.
No
Any
objection.
objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. Is to grant the state's motion, revoke the defendant's community supervision, reform his judgment to a sentence of 3 years in prison. And the state is going to take into consideration cause number 2025 PF 31486 and 2025 PF 31487.
All right, and what are those allegations in those?
It's an unauthorized use, Judge, and a possession conviction.
All right. So what has he done on probation other than pick up new cases?
Your Honor, the times that he had missed, and it's, we have waived, those of allegations obviously have been waived, but if the court looks at the MTR, he was in Medina County for another offense.
All right.
Fundamental.
So was he ever released while he was on probation?
You did report some of
Yes,
correct?
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
ma'am.
All right, you can lower your hand, state your name for the record.
Anthony Ramirez.
All right, so what have you done other than it's alleged that you picked up 2 new cases?
I reported like 3 or 4 times. I paid those times that I did go report.
All right, so you've reported 3 or 4 times since October 2024.
Whenever I was released from here, I reported like 3 times, three times.
So why are you only reporting 3 times?
Because after that, I was in Medina County.
And in custody in Medina County for what?
Unauthorized use.
All right, and is that an unauthorized use that's alleged to have been committed after he was placed on probation?
My understanding is yes, Your Honor, but out of an abundance of caution, would just simply ask the court, or we have the summary here. I'd like to, just take a look at the dates just to make sure, but I am pretty sure it was after.
Okay.
Yes, sir.
That was after the new charge after you got released.
Yes, sir.
So then here's my question for you. Why should I give you less than what you bargained for when the only thing you've done is report 3 times and you picked up a new case, you ended up in Medina County, and then you have 2 new charges here that the state is taking in consideration? And I'm assuming those 2 new charges, was that after he was placed on probation?
Yes, Your Honor. They were August.
So why?
Well, these cases didn't have nothing to do with me as far as the unauthorized use.
Okay.
How it all happened is, if you look into it, but
And what were Your Honor, on the unauthorized use here, basically he was with a But I would think that the evidence would suggest, I don't want to put words in about the evidence would suggest that the actual taking of the vehicle was by another young lady in Corpus Christi that he had an engagement with here in Bear County that may or may not have involved provable possession of illicit substances, Judge. But it's not, but in no way are we trying to represent to the court that it's acceptable behavior as on while he's on probation. We would ask the court to, though, give some consideration, even though we've been here before. This is a young man who's basically been raised in prison. He went to prison for the first time at, I believe, 14. He has had some issues with his decision-making, Judge, but with the underlying sentence of 4, we think, well, that's the plea bargain process, and so we think the 3 would be fair, but we would yield to the court on that. The other thing that could be done at this time, if he didn't have the cases pending in Medina County, I will say the first thing that came out of his mouth is that he needs help with his, would you agree? Help with I'll let you complete my sentence.
With that, Judge,
Well,
I really do need. Yes,
Okay, good.
I really need help with the substance abuse. That's the whole point of it. I'd rather have take the 3 years of TDC just to, overall, I think it'll help me out than to just go out and do the program, whatever it is.
But I mean, you were given a chance when I placed you on probation to get it together, right?
The problem is the drug problem. I was still.
Oh, no, you could have came here and I would have said, okay, let's take care of your drug issue. Let's give you whatever help you need with drug issues. But you didn't reach out to your probation officer. You didn't reach out to the court. You reached out to take a ride with somebody in a stolen vehicle. And the last time I saw you, did you have the teardrops or is that something new?
No, same thing.
All right. And then the crown.
All the same.
And then the Playboy bunny.
Everything.
And then the dollar sign.
It's all old.
Yeah. How old are you?
28.
All right. You're 28 years old and you went to prison when you were 14. You know, TYC, that's what we would call it.
TDC.
Is somebody sending somebody to TDC at 14?
I think Your Honor, given.
No, I mean, you start out in TYC. They're not sending 14 years old to prison. Then once you become of age, then they will send you to prison. So I can see you.
Sentenced at 14, then 15, I was in TDC, the Clemens unit, YP. From all the way till I was 21.
Well, is somebody going to sue Texas for sending a 15-year-old to prison?
Your Honor,
I'm always interested in learning new law. There are a lot of defense attorneys in here. Do they send people in Texas to adult prison when they're 15?
Your Honor, I think that just sometimes, okay, and again, not to contradict what he's saying, but I think sometimes it just kind of blurs and runs in together when you've been in since you're 14.
Well, let me just tell you this.
I can tell you this, there's so
any legal advice, but if you were sent to prison at 15, somebody needs to file a suit, although the statute of limitations may have ran since you're 28. But this is what I can tell you.
And for the record, Your Honor, obviously, I did not represent him.
No, I appreciate that.
For people in.
This is what I can tell you. At some point, your actions are your own. You can't keep blaming your actions on the fact that you went to TYC at 14. You got to change your life. All right. I'm going to follow the agreement that you worked out based upon what your attorney is saying and what the state is saying with regards to the unauthorized use. I guess that's what we do since the time of Adam and Eve. We still blame the woman for our own actions. So, are you waiving your right to appeal?
Yes, ma'am.
All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served, I'm going to request the therapeutic community. There's to be no unsupervised contact with minors, no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. When you're released from custody, if you can't find somebody to help you get on the straight and narrow, if I'm still here, you can come back here. I'll find an inpatient treatment facility for you. Now, let me just explain to you, the reason why I'm saying no unsupervised contact with minors and no residing with minors is because you really shouldn't be around minors, because you'd be a bad influence. And until you get your life together, that's the way it should be. And a lot of women will see you when you come out of prison, and they're going to see somebody who's a good catch.
Yes, ma'am.
And we can't have that until you get your life together, okay? All right, good luck to you, all right? Oh, and I'm so sorry. Can we go back on the record? Court is going to take in consideration 2025 PF 31487 and 2025 PF 31486. And if you could hold him for a moment so he can get a copy of this, please. Yeah, thank you. And I don't know if you all have a case number for Medina County.
I believe they were listed on the NPR judge. But
Well, if you all have that and you bring that number back to me, I'll make sure that this runs concurrently with that.
okay, I'll get that for you, Judge.
All right, thank you.
No,
I
it
mean-
was initially that he didn't drive after the accident.
Mhm.
And then it took a long time for him to get back in the car. Once he got back in the car, he had been driving to work and back. That's it. To work and back. He lives in residential area, but I'm not,
So in this case, we're here for restitution. Are
Yes.
y'all prepared?
well, we were just served with discovery. And so on that, no, because they're asking for restitution, which we had no notice of, until today, about, I don't know, an hour ago.
All right, so State, do you have any witnesses for the restitution hearing?
I did hear, and this regarding the document that she was served, I served them on her. I received it this morning and I served them on her as she appeared. 30.
All right, so do you have any objection to their witnesses appearing by Zoom for the restitution hearing?
Yes, I do, because the lack of, so we filed a 3914 on February of 2024. And, to our knowledge, there was no restitution at this point. We don't have the ability. We know that he was paid 30,000 in restitution from a insurance claim out of the insurance that covered the car that my client was driving. And so we don't have those documents. So at this point, we would let the court know that we can't proceed if they're claiming they're still entitled to restitution, even though they've been paid 30,000.
All right, so this is what are your witnesses going to be available at another date or no? All right, if you want to talk to them and see if they're available to testify at another date, if they're not available, I'll take their testimony, and then if they need to be recalled, they can be recalled.
Okay.
And I got your ex parte
There's
request. So what I have to do is I send that it'll be sent under seal to the voucher committee. They'll look at it, and they're very quick about a quick turnaround, and then I can sign off on it.
okay.
All right.
But she's not available to testify today.
All right, I'll take testimony today, and then if they need to be recalled, they can be recalled.
Great. And then, Your Honor, we do have two other issues that we'd like to address today too, just to put on your radar. And that is
To reconsider.
motion to reconsider. And then the second one is that conditions of probation were amended yesterday without notice to the defendant. I think there was a report that was sent to the court that had to do, and it's not necessarily we're objecting to it, but we've not seen it. And he was ordered out, dual diagnosis, outpatient, AANA. We haven't seen any of that documentation. I talked to your court liaison and she said that she can give us copies of it to review. But you'd have to authorize that.
All right, so I had ordered a TAP and MIC evaluation in custody. So are these the results of the TAP and MIC?
The TAP evaluation came back with dual diagnosis outpatient program. A supplemental report was submitted to the court yesterday or day before yesterday, and it said for those conditions to be amended. Those conditions have not been amended just yet, but it is for dual diagnosis outpatient program, sober support meetings documented, and monthly UAs.
Okay, all right. And can you let her view the report, the recommendation, the TAP recommendation?
Judge, I need clear direction. Then are you saying give her a copy of it, or are you saying let her see it?
She can have a copy of it, but it's not to leave the courtroom.
I'll return it upon after review.
Can you forward that to the voucher committee? All right, court is calling 2023 CR 8868 State versus Samuel Allen Bach. Could I have parties announced for the record?
Megan Galloway for the state.
Jody Sawyers for the defense, along with Samuel Bach.
And are you Mr. Bach? All right, so Mr. Bach, the deputy will tell you to stand there. We're here for a restitution hearing and also motion to reconsider conditions of probation. So we'll start with the restitution hearing first. State, do you have witnesses?
Yes, Your Honor. State plus Crows to make us Mr. Bach, Judge, I would just ask you to take Judas for notice of the evidence that was also trial as well.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear.
All right,
All right, and excellent. If you'll state your name for the record.
Carlos Dominguez Jr.
All right, you may proceed.
Thank you, Your Honor. Mr. Dominguez, are you the same Mr. Dominguez that testified in the guilt and innocence portion of the trial against Samuel Bach?
Yes, I am.
Okay, and in that testimony, you testified that Mr. Crows Dominguez Senior was your father, is that correct?
Correct.
Okay. Now regarding the death of your father, did you make any arrangement for your father after he passed away?
Yes, it was Trevino Funeral Home.
Okay, and did you have any pocket expenses associated with those funeral services?
Yes, we did.
Okay, and did you bring documentation of that to court today?
Yes, I did.
Okay, so I'm gonna show you what has been marked as State's Exhibit number 1.
And just one moment, off the record. All right, you may proceed.
Mr. Dominguez, I'm showing you what has been marked as State's Exhibit RP. Do you recognize this document?
Yes,
Okay, and is this a fair and accurate depiction of the documents that you provided this morning?
correct.
Okay, and now regarding.
Oh, just in case.
Thank you.
All right,
I'm showing you what's been marked as State's Exhibit RP on there. Do you recognize that document?
Yes,
Okay, and is that a fair and accurate depiction of the document you provided with this morning?
yes,
Okay, now regarding the funeral services for your father, do you recall where they were made at?
at Trevino Funeral Home.
Okay, and is that located on Couples Road here in San Antonio, Texas, Bexar County?
Correct.
Okay, and regarding the out-of-pocket expenses that you had associated with that, can you tell the court what was the balance that came out of your bank account?
Objection, hearsay,
overrule.
and also objection, no personal knowledge. If he's not the executor of the estate, a foundation has not been laid as to him having the authority to have it come out of his bank account.
Well, the question is, did it come out of his bank account?
That's what I was asking. So he would have personal knowledge if it came out of his specific bank account.
Oh.
The counsel's objection if she doesn't know where it's coming from.
All right, so here's the court's question. Did it come out of your bank account?
My dad's account, which I was the executor for the account.
All right, the objection is overruled.
Okay. Now, what was the total cost that was outstanding for the funeral service?
And Your Honor, I'm going to object that we have not been provided any documentation that this came out of a bank account. So any testimony in regards to what was distributed from the executor's account, we object under 3914 failure to disclose.
All right, objection will be overruled.
Yes.
It was $4,545. and 51 cents.
And is that the amount that you paid to the funeral home for the funeral service?
Correct.
Okay. Now regarding your father's home, was at the time of his death, were you living with him or was he living by himself?
He was living by himself.
Okay. And did you have any out-of-pocket expenses associated with his home after his death?
Yes.
And can you explain to the court what that was?
It was stuff that we were just getting rid of the excess stuff so we can get rid of the property and everything. Because none of the family wanted to keep the property. So it went through a junk lugger
Okay.
and it took 3 trucks to get it done.
Okay. Now regarding that expense, I'm showing you what's been marked as State's Exhibit RP2. Do you recognize this document?
Yes.
And does that appear to be an accurate copy of what you provided me this morning?
Yes.
Okay, and can you tell the court what was the cost associated with that removal of the property from the home?
In your honor, again, I'm gonna object. This was not provided to us until 9:30 this morning, and we still have not gotten a copy of this. We're just informed that it existed.
All right, objection will be overruled.
You can answer. So what was the total cost?
The first cost was $909.30, and the second cost was $1,204.77.
Thank you. You pass the witness, Your Honor.
All right, any questions?
Yes. First off, you would agree with me that the estate of Carlos Dominguez was paid $30,000 from a USAA settlement, correct?
Yeah, I do not recall $30,000, and I don't agree with you on this.
Are you under oath right now?
Yes,
Okay, and you're the executor of that estate?
yes.
And what amount were you paid was the estate paid by USAA for this accident?
That amount I do not recall. The total amount I do not recall.
And was it over $20,000?
I don't recall.
Your Honor, this is why I'm objecting, is because
All right, so here's the thing. I've already made a ruling on the objections. I'm just having him testify now. He can always come back to be recalled to testify. This is what I'm going to tell both sides. With regards to these amounts, if there was an amount paid by USA settlement, then what the court needs to know is whether or not the settlement that was paid by USAA, if it was supposed to be for funeral expenses. It is not, if it's not for funeral expenses, then he is going to have to pay for funeral expenses. Now, with regards to the removal of property from home, everybody needs to bring me case law on that, on whether or not he is really entitled to restitution for that amount. Because what I can tell you, sir, is sometimes people will come to me and they want restitution for, I had to be out of work for a certain amount of days. And I'm not allowed to give, legally, I'm not allowed to give restitution for that. So both attorneys are going to have to bring me some sort of case law that will say that the removal from items from his home that you said went to, you titled it junk removal, and that's what I'll call it. The $909.30 and $1,204.77. So that was removal from items from his home. I'll need some case law on that. If somebody can bring the court case law that he is entitled to restitution based upon that. With regards to the funeral service amount, there is no question for the court that if that amount hasn't been paid by USAA, whatever the funeral expense amount is, that restitution should be paid by Mr. Bach. However, if documentation is brought to the court that in USAA, if that's the insurance company who covered expenses, if it's itemized in there, the funeral expenses, then if it's already been paid by USAA, you don't get to get it paid twice. You understand? So that's what the court needs. So we're going to recess the restitution hearing, and I'm going to give you all another date to come back, and you'll have a chance to look over whatever you need to look over. And then on that date, the court will make a ruling on the restitution. Okay? So do you understand, sir? All right. So Ms. Ferguson, with regards to the restitution hearing, give me a 30-day reset on that, please.
Yes, ma'am. October 16th.
All right. So we're going to continue with the restitution hearing on October 16th. All right, sir. Any other questions
Yes, John.
of him? Okay, she has some more questions for you.
So, do you have access to the bank account, for records for the executor? Like bank account?
That account has been closed. Yeah,
You were the executor, correct?
yes,
And you opened the account?
no,
Who opened the account?
my dad.
Okay, so it wasn't then, the executor's account.
I was on the account with him. When he deceased, well, on the, everything that was there, he had me down as the executor.
Okay, so the funds that, the account that you claim that you paid that, 4,000 and some change for the funeral expenses, do you have, are you on the account? Did you sign the check?
We used the credit card.
Okay, so it didn't come out of the executor's account?
Yes,
Okay, who owns the credit card?
I did.
Okay, so it's your personal credit card that
No.
paid?
That's the credit card that my dad and I were together, yes. We
Okay,
were together on it.
and so you have access to those statements, correct?
Not no more.
So you don't have access to the credit card statements?
I can ask the bank, see if we can go back on the deal. I don't know what we can or not.
Okay. Now, also, who signed or accepted the payment from USAA? Was it you?
I did,
Okay, and are you the one that signed the settlement agreement?
yes.
Okay, and so you have a copy of that agreement as the executor?
I just like I said, I'm gonna look at my computer because I downloaded everything into my computer. And I still have it from my dad.
Okay, thank you, Your Honor.
All right. Any other questions?
No, not from.
All right. Thank you, sir.
Anyway.
Okay, and then,
All right. The next thing we're going to take up is you have a motion. You can come back, Mr. Bach. You have a motion to consider reconsider conditions of probation.
yes, Your Honor.
Yes.
At this time, at the time of the trial, you ordered 6 months of jail as a condition of probation. And at this time, he served over a month. We are asking for the court to reconsider. He had spent over 2 years on partial house arrest. We believe that he's a good candidate to hold that in abeyance. And, if there's ever any issues, you still have that at your disposal. This is not, a give me, it's more of an earned kind of thing. But he did, from the time of the incident, which has been over 3 years ago, he has not picked up any other driving violations. And at this time, we would ask the court to reconsider on that.
All right. Correct me. Wasn't the testimony that he doesn't drive?
No, it
I mean-
was initially that he didn't drive after the accident.
Mhm.
And then it took a long time for him to get back in the car. Once he got back in the car, he had been driving to work and back. That's it. To work and back. He lives in residential area rural area that doesn't have any public transportation. And the second thing to be considered would have been, if he is allowed out, and if that's held in abeyance, then we would ask that he have permission to drive the limited purposes of going to, work, his probation, his also, from what I'm seeing, they're recommending dual diagnosis, outpatient treatment, AA, NA, so he needs to be able to get access to those.
All right. So with regards to the AA and NA, is the court's understanding that those can be accomplished online?
Oh,
Is that correct? I believe it can be. AA or NA meetings that can be accomplished online?
Providers that have the online capability.
All right, state response.
We are asking that you, deny their motion and leave the sentence as it was imposed by the honorable court on the date of sentencing. Regarding the 6 months, that is something that the state was seeking in punishment, as punishment, given the testimony and, or the testimony of the defendant specifically and punishment. And then regarding, his being able to drive, I just don't think that, given the facts of the case that were proven in the trial, that there are sufficient means to supervise him in a motor vehicle, and so we're asking that you leave the sentence as it was in the date of sentence.
All right, then the next thing is with regards to the TAP evaluation. Have you had a chance to review that?
I have not, Your Honor. Can you give just a second? Yeah, and so, Your Honor, I have now had a chance to review it, and it looks like he has denied alcohol and marijuana use since January 22nd, 2022. And so at this time, I mean, I'm not quite sure that it's appropriate to order the dual diagnosis outpatient or the AANA, just because it doesn't look like there's a continued usage. It looks like he's gotten a hold of whatever was happening there. That doesn't mean that he doesn't need maybe mental health treatment, but as far as the alcohol and drug usage, that stopped over 3 years ago.
All right. So with regards to the TAP evaluation, they're experts. I'm going to follow the TAP recommendation. With regards to the motion to reconsider conditions of probation, the court is reconsidering those and the motion will be denied. So we will bring you back on October 16th. And at that time, we'll continue with the restitution hearing.
Thank
All
you, Your Honor.
And state if you will make sure that if there's any documentation from USAA, that the defense has access to that.
Yes, sir.
All right, thank you.
Thank you. I appreciate it.
Okay.
Have a seat, sir.
Oh, I'm so sorry. Back on the record briefly. So with regard to the TAP evaluation, Ms. Abrams, the court is following that, but I'm not going to order that he be on sober support meetings for the duration of his probation. I'm going to ask for 60 sober meetings in 60 days. All right, thank you. Yes, after release.
Clerk Payne for the state of Texas.
Sharon Thorne for the defendant.
And are you Alicia Rubio?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alicia Rubio who was placed on community supervision in 2022 CR 3602 for the offense of assault family household member with a previous conviction on June 30th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violation of condition number 39. On or about the 3rd day of January 2025 in Bear County, Texas, the defendant, Alicia Lubio, who then and there failed to attend felony drug court evaluation in violation of condition number 39.
How do you plead to that? True or not true?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition 39, the court could find it true, grant the motion, and sentence you to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
Court will find violation of condition 39 true. Is there a proposed agreement?
There is not. That is to deny the motion. Alter and amend the defendant's probation conditions to add DDRF followed by DDRF aftercare.
That is our understanding, Your Honor.
Why should I do that?
Your Honor, my client definitely needs help. She's had a lot of mental health issues and depression. Her father died, and she just basically didn't even get out of the house and did not follow any of your terms of probation, but she does want help, and she needs the help. And the state and probation wants to help her, so we're asking you to do that.
All right, so this is not the first motion to revoke she's had with me. Has she done anything on probation?
She's done some community service hours.
In all my communities. And
Other than that, I don't think we'll see a lot.
All right, probation, what has she done?
Judge, I would have to look into the community service hours part of that. But the only thing that I have that she has completed was basically her TAP evaluation. She did her DNA testing and there's a $90 credit on the account.
I mean, she hasn't done anything, and we've been here before. And the court recommended felony drug court for her because we had issues with drug use. And nobody can help anybody who doesn't want to be helped. She was here December 2024 for a violation of condition number 4, not reporting, disappearing. I denied the motion, alternate amended conditions to include a TAP evaluation out of custody, a mental health evaluation out of custody, and a referral to felony drug court out of custody. And then she disappeared, and she's been missing since January. So it's obvious to the court, there's nothing that I can do here. So I'm going to grant the motion and revoke. Do y'all want to recommend amount of time?
Say what she 4 years.
Defense.
Your my client, she has 209 days credit, but my client is asking for you to consider reducing that amount to 2 or 3 years, Your Honor. Not to make excuses, but the gentleman that you had before picked up new cases and he
All
gets
right,
3
so
years.
here's the thing. Let me explain something. And defense attorneys will tell you this all the time. And I used to have clients, they said, well, this person got that. Why can't I get this? Or this person got that. Why can't I get that? I treat everybody as an individual because guess what? If I didn't treat everybody as an individual, everybody comes before me. And usually, you know what they tell me? Somebody died in my family. I just got a job yesterday. And if I didn't treat people as an individual, you know what I'd be doing? All those stories that people tell me, sometimes they're true, sometimes they're not true. I would hold it against you.
Right.
So what somebody else receives may not be for you.
Right.
So I'm just looking you at an individual and you're looking at 4 years because that's your range. And what I can tell you is the person who just came before me, because your attorney brought it up, they didn't have a previous motion to revoke.
Right.
So this is your second motion to revoke. And you're coming before me and I tried to help you with the MIC evaluation, which is what everybody's saying you need. I already tried that. You didn't want it because you didn't do it. I tried helping you with your drug issue. That's why I had felony drug court. You didn't want it. You didn't show up.
Right.
I tried helping you by giving you a TAP evaluation. If you were not accepted in felony drug court, you didn't want it because you didn't show up. So the state is asking for 4 years. Yes, the state is asking for 4 years. Your attorney is asking for 2 to 3 years. What I can tell you is I'm not giving you the minimum because you didn't do anything. And this is your second motion to revoke. So you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Alicia Lubio.
All right, what would you like to say or defense? Would you like to speak to her before she speaks to me or?
I believe she wants to state why you should give her the 3 years, Your Honor. And I'm going to allow her to speak her mind.
With all due respect, Your Honor, I'm requesting your leniency, yes. But I did do my Zoom, my TAP evaluation through Zoom. I did that. I can't pinpoint the exact date, but more or less, it was before the first MTR. I did that through Zoom.
Mhm.
Y'all couldn't find it the first time I came through here, which is why you recommended the second one. Okay, I went through 4 probation officers, 4 different probation officers while I was out there. My last one was Mrs. Spence. I did my parenting class that y'all requested. I did my community service. I recorded my change of address.
Did you turn in your parenting classes to them?
Yes, I did.
Probation, can you look to see if you have documentation of parenting classes? Go, continue.
I had, my sponsor, I gave her my sponsor's information. I gave her,
Everyone, please whisper. You may continue. Sorry about that.
thank you. I gave her the information to the program that I was working in San Antonio at Zapata. I gave her all that information. I was doing my meetings at 2:00 and at 6:00 every day. She had no record of that when my paperwork got to her. And I hold myself accountable for every, missing and not and failing to report. That was my irresponsibility. I agree to that. Yes. My depression was something I couldn't control. I wasn't on my medication. I didn't have the strength to leave my house. You know what I mean? I'm not saying that's anybody else's fault but my own. You know what I mean? I'm trying to learn to hold myself accountable. So I'm doing that. I do have a drug problem, but I have been clean. My drug of choice is heroin. I have been clean off of that since I picked up this charge because my priority is to get back to my mother, especially since I lost my father in March. I want to be with her. I want to grieve with her. I want to do all of that. That's why I'm requesting your leniency. You know,
All right, so here's the thing. I don't know if you've been clean or not because nobody's tested you. You're just telling me this.
The last drug test you requested from me, I was here in your court. It was the same thing. You didn't believe me, and I said I was, and you sent me to drug court to drug test, and my drug test came back clean. You know what I mean? I hold proudly that I'm from where I'm from, and I've been clean. That's something I work very hard to do every day. Because as an addict, that's difficult, especially when I'm grieving the father, my father's loss, or losing my father. I apologize.
You've
That
been
was
missing.
nothing to do.
Here's the thing. You've been missing since January. So I don't know what you've been doing. That's the problem.
And I take that. That was my responsibility. Again, I'm just asking for your leniency. I want to get back to my mom.
All right, probation. Do you have proof of the parenting classes? All right, this is what the court is going to do. The court is finding violation of 39 true. Court is going to grant the motion. The court is going to sentence you to 3 years in the prison. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Ophelia, Ofelia, Rubio. Give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, counsel?
Yes, Your Honor.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction and a finding of affirmative violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. With regards to the therapeutic community, it doesn't increase the time that you're in custody, but that can help you with any drug issues or mental health issues you may have. Once you're released from custody, if you cannot find a sober living home or somewhere else, just let the court know. If I'm still here, I'll pick up the phone, call somebody to help you. All right? All right. Good luck to you. Okay?
I have a question, so I'm gonna able to see them.
She's a no
She's my
contact.
victim.
She's a no contact.
Oh, no, you have a no contact order with her.
Even after I get out?
Yes.
I'm just right.
All right. Are we ready on anyone else? Good morning. Court is calling 2025 CR 007217. State versus Desmond DeBryan Gomez. Could I have parties announced?
Megan Gallagher for the state.
Christian Vega for the defense.
And are you Desmond Gomez? All right. We are here for sentencing. Just one moment. All right, Mr. Savage, we're on the record. You're going to have to whisper. That's okay. All right, according to the plea paperwork, it says that you entered a plea of no contest to counts 1 and counts 3. Is that correct?
Yes, Judge. He was running a concurrent, it was a plea for concurrent deferred, and we were recalled for a TAP evaluation and a MIC evaluation. The report-
No, I'm just wondering because the docket sheet says something different. So I just want to make sure that the paperwork is correct. So count 2 was waived?
I would have to look at it, Judge. I'm sorry.
That's okay,
Thank you.
because I have count 2. Oh, I'm sorry, there are 2 case
Yes,
numbers,
2 and 1. That's
2 and 1. Thank you.
Thanks, Judge.
All right, so you entered a plea of no contest to counts 1, counts 2, and counts 3. All right. And it counts Counts 1 and 3 are third-degree felonies. Count 2 is a state jail felony. And according to your plea bargain agreement, in each case, the state is recommending deferred adjudication. And just one moment. Do you have any objection to the court reviewing the information that probation has sent?
Oh, not at all, Judge.
All right. Have both parties had a chance to review the mental health evaluation and the TAP evaluation?
Yes,
Any
Judge.
objections?
None.
All right. All right, so they're not recommending that he be placed on the mental health caseload. And then with regards to the TAP evaluation, they're recommending residential treatment. Did you want to address that, counsel?
Yes, Judge. Clearly it's within your discretion. There's SATF with aftercare, intensive outpatient with aftercare, and in the event he either anxiety worsened or they due to issues on probation, if there was ever a need for MIC placement, they said they'd reevaluate that. He does not have an extensive criminal history at all, but in addition, regarding drugs, drugs were involved in the offense. He does admit to substance abuse, several serious drugs. I think he could benefit from some treatment, but he has never been on a probation before. So I think intensive outpatient could, I think that would be very beneficial to him. He's been in custody for quite some time. He's not bonded out, and maybe SATF could be held in abeyance while he does do intensive outpatient treatment.
Probation, what are you recommending as far as, I know the TAP evaluation is requesting residential treatment. What are you recommending? Are you in agreement with the lesser modality?
Judge. I think that has been in touch. I would be in agreement with the less modality. With the understanding if any positive plays or anything comes up that you would go into status.
All right. And then the other question I have, it mentions that his family's in Beeville.
He does have some family out there. Yes, Judge, but he also has a family in town.
So is he going to be remaining in Bear County?
Yes, Your Honor.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right. You can lower your hand, state your name for the record.
Desmond DeBrian Gomez.
All right. So I do remember your case. Now that you're before me, do you need a cough drop? Yes, actually. Thank you. Thank you. I tend to remember faces, then I can connect that to the facts that I recall. So, when is the last time you had any type of treatment for mental health issues?
Can't recall, like as far as inpatient or outpatient, I just have a normal family doctor that has given me antidepressants and other medications throughout the past maybe 6 or 7 years. Sure.
All right. So when's the first time do you recall seeing a mental health doctor? How old were you?
No, probably like 10 years old.
Okay. Because, counsel, I'll tell you what, even though I know what the mental health people are saying, what I find concerning is your attempt to commit suicide in the vehicle.
Yes.
So are you having any contact with your children now or no?
I've been talking to them over the phone, but I haven't seen them in probably since before I had gotten arrested about 6 months ago.
All right. And who is your support system here in Bear County?
In Bear County, my grandmother, and I have 2 aunts that I talk to over here.
All right. How far did you go in school?
11th grade. And then that's when I had my daughter.
Mm-hmm.
And I just stopped going.
So have you worked on trying to obtain your GED? And have you been successful with that or no?
Still in the process. I was in the process right now while in custody. And I've tried, but it's really been hard for me.
All right. Have you had any type of employment before?
Yes, ma'am.
Doing what?
Surveying.
Okay. So what I'm going to tell you is I'm going to do, I'm going to start you with outpatient treatment. And you're going to have to really communicate with your probation officer because I'm going to grant your application for deferred adjudication. But these cases, if you're unsuccessful on deferred adjudication, and if a motion to revoke is filed, I'm not saying it could happen. I mean that it will happen. But on the state jail felony, you will be looking at 2 years in the state jail facility, and that's day for day. The other cases that are the other counts that are third degree felonies, you'd be looking at 10 years. Do you understand?
Yes, Your Honor.
So you're going to have to communicate with your probation officer, and your attorney will tell you in this court, if people are struggling with their drug addictions, all you have to do is let your probation officer know. And you know what's going to end up happening? If they tell me that you're using again, I'm going to receive a supplemental report from them. And they're going to tell me that you're testing positive for drugs. And you know what I'm going to do? I'm going to set it for a compliance hearing. I'm going to have you come in, and we're going to see. And maybe you need inpatient treatment. But if you do this thing where you disappear, that's going to be a major problem. You understand? All right. So this is what the court is going to do. Counts 1, 2, and 3 are to run concurrently. There's to be no contact with Olga Cisneros. The reason why I'm doing that is because all of this started because you all were in a fight.
Yes, Your Honor.
I may change that at some point in time, but for now, you need to focus on you. You understand?
Yep.
There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Take in consideration 2025 PF 13273. There's to be restitution, if any, to Juan Vertiz, Vertiz. James Trottie, Trottie. There's to be the MRT, anger management, 200 hours of community service restitution. The court is going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied if the defendant obtains his GED or trade school certification. I am going to order the parenting classes, the trade school or certification. That's up to you. Either you can get that done or either you can do 100 hours in the heat of San Antonio. Do you understand?
Yes, Your Honor.
There's to be intensive outpatient treatment with probation and a referral to Center for Healthcare Services and 60 sober meetings in 60 days. Probation, is there anything else? Thank you. Field visits 1 time per month until further notice, and there's to be no residing with minors.
The name for one, for the restitution, verify the last name.
Bertiz.
Is a Victor, he's a boy.
Oh, B as in Victor.
Okay.
All right, and there should be no unsupervised contact with minors. Is there anything else you need from the court to help you be successful on this probation?
I guess it's giving me everything to think that I need as well.
All right. If you need anything else, be sure and let the court know. Counsel, for some reason, I do not have a copy of the trial court certification.
Okay, we can do that.
So if you could just grab one for me, please.
Did you have the term for the probate, the sorts?
Oh, thank you. 5 years deferred adjudication.
Thank you.
It feels like it's a Monday. This is what happens when I leave for a certain amount of time. Do you know in some places people are on probation for life? I've never heard of such.
Sounds difficult.
And I'm sorry, Vashon, you need to write a letter of apology to James Trotty. You understand?
Yes, sure.
No one likes to be spit upon.
Yes, sure.
So, Ms. Abrams, he's going to write a letter of apology to James Trotty. And state if you have that dismissal from him. It's a 2025 PF 13273.
Oh, sorry, Chad. Got it myself.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
Thanks,
You're
Judge.
welcome.
Seat, sir.
Yeah.
Have a seat. Have a seat.
All right, so then my next question for you, Mr. Crawford, when are you going to have this $3,746.99?
I don't know exactly, but
You think okay for Mr. Crawford?
And are you Mr. Crawford?
yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Crawford, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, sir.
Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Crawford, did you review court admonishments with your attorney? Did you understand it?
Yes, sir.
Did you sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Crawford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand by entering this plea, if you are not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the country? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution in the amount of $3,746.99 to target. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there been any such motions? Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with target, and Michaela, Makhayla, Pean, Pean, a mental health evaluation, follow recommendations, the anti-theft course, and healthy relationships course. Did you understand those were recommendations by the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I'm guilty.
I believe the paperwork says no contest.
All right. Do you understand what a no contest plea is? You're not saying that you're guilty in layman's terms. You're not saying you're guilty. You're not saying you're not guilty. You're just not fighting the charges against you. However, I can still find there's sufficient evidence to find you guilty. But because you've applied for deferred adjudication, if I follow your agreement, I'm not going to find you guilty. I'm going to defer finding of guilt. Do you understand?
Yes, sir.
Normally, people will enter no contest pleas if there is any type of restitution is owed, because people can always sue you civilly. So sometimes your attorney is trying to protect you civilly. So by pleading no contest, if there is a civil suit involved, whoever wants to sue you out of something that arose from this incident, they would have to go to a civil court and prove that. Do you understand?
Yes, sir.
So are you pleading guilty or no contest?
No contest.
All right, state any evidence to support the defendant's plea?
State offer states one in attachments.
No objection, Judge.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so here's my question. I see that they say that he stole Apple iPad Air, which I understand. But in one place, on June 24th, 2024, they say he stole an Apple iPad and it costs, an Apple iPad Air, and it costs $799. Then they said he stole another Apple iPad Air and it costs $1,200.
This is our based on like the storage space that the iPads have. And so like if it's like a 60 gigabyte, then that would be cheaper than a 120 gigabyte storage. So I think like nice to you, but
Sure. So the Apple iPads have different
they have different storage.
Oh, okay.
Yeah, so I did attach those, and so like
Okay.
here you'll see the storage on it.
Thank you. That explains it.
Guess otherwise you'd want to go shopping.
I'm sorry?
I guess otherwise you'd want to go shopping for the cheaper iPad with the same storage.
Oh, I have no idea. I don't do Apple. No offense to Apple. I
Yeah.
just, My thing is, I'm not trying to learn anything new, computer related. I still on my phone, which is, I think, a 6, and they're already on 29. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding you guilty as you've applied for deferred adjudication. So these are some questions I have. Number 1, why is there a request for mental health evaluation?
So the recommendations that are below the line are based on my analysis of a different case. So it's a global offer where he's not going to be on supervision for the misdemeanor case, but that's where the conditions are.
All right, so that's the mental health evaluation is based upon the misdemeanor case?
Yeah, the mental health evaluation, the healthy relationships, and then the no contact order with the named individual.
All right, and who is the named individual? What's the relationship to the defendant? Okay. All right, so then my next question for you, Mr. Crawford, when are you going to have this $3,746.99?
I don't know exactly, but less than a year for sure, or less than like
When are you going to be able to make a down payment towards this?
as soon as possible.
What does that mean, though?
I get paid on next Tuesday.
All right, what do you do?
I work at BJ's restaurant.
All right, so how much you're going to be able to pay towards this?
I can put down 300.
300?
Yes, ma'am.
All right, when will you be able to put down 500?
500. I don't know the exact date, but I have a phone on me.
Oh, do you want to look at a phone now?
I have my phone on me.
Okay, oh yeah, you can look at it.
The 16th of October.
October 16th?
Yes, ma'am.
All right, so this is what we're going to do. I'm going to sentence you. Norma?
Yes.
Are you able to recall this back on October 21st?
Yes.
All right, so you're going to be sentenced on October 21st. Ms. Abrams, he's going to have $500. Should he make that out to someone other than, all right. So he's going to bring in $500 towards Target. And then when you come back on October 21st, you need to be able to tell me how much you'll be able to pay per month towards this restitution. All right? So we're going to recall you back on October 12th.
Did you say October 12th or?
I'm sorry, October 21st. Yeah. The days are just all over my head today. So we're bringing you back on October 21st. On October 21st, you're going to need to bring $500. Do it in the form of cashier's check or money order. What do you need? All right. So either a cashier's check or a money order. And usually the money orders and cashier's check, they usually cost the same. So you can get the cashier's check or money order from a bank, or either you can get the money order from, HEB or some of those other stores. All right. So we will see you back then. Once you get the reset form and you sign it, you're excused. Okay.
Yes, sir.
All right. Thank you.
Judge, will you need me on that? Will you need me on that?
Oh, yes.
Okay.
Judge, let's just go restitution or sentence.
Sentencing.
Thank you.